Hi, good evening, guys, and good morning, good afternoon, depending on where you are. Um, I'm just handling the technical bits. This is Richard Agyakwa, and my first off, I need to point out to you that once you have the video window open, you look on the top right corner next to your name. On the top right corner next to your name, you will see a rectangular tile. Now you click this rectangular tile and you can see a Q&A icon. When you click the Q&A icon, it will give you the opportunity to start sending in your questions. Please start sending your questions soon as the presentation begins, okay? So I'll hand over to Edwin, who would just introduce the guest speaker and the topic, okay? So Edwin, I'm muting, Edwin and Sam, I'm muting my microphone. Edwin, once you finish the intro, you also mute.
Right. Thank you and good evening, colleagues. We are very happy, with the rate of response. When we appear to have landed on some technical hitches, we could see that guys were really anxious. Thank God we are through now. We have one of our own, lawyer Sam Opoku Agyakwa. He is presenting a media edition of our monthly series, a series that is intended to share our varied and diverse expertise. He wants us, as we've already notified ourselves, to take charge of our affairs whilst we are dead. And so, because we are hard pressed for time, I'd want to straight away introduce Mr. Samuel Opoku Agyakwa, to take over the floor. I'll be muting my mic, and so you will only hear the voice of lawyer Opoku Agyakwa. And as Richard has informed us, you are to send your questions as soon as the presentation begins. I think we have Ernest Bar on the wrong link. Ernest, you're on the wrong link. But if you can't go to the right link, you have to mute your mic. Yes. Right. Okay. So, lawyer, the floor is yours. Could you please do justice to the presentation?
Thank you very much. Fellow Odadee, I am Samuel Opoku Agyakwa. In making this presentation, as requested by our national executives, the title I have chosen for the presentation, and maybe I'll say it's a sermon, it's entitled, "My Will Be Done on Earth as I Rest in Peace." I will start this presentation by reference to the Bible. If any of you have your Bibles, you may turn to Hebrews chapter 9, verse 17, and I read, "For a will takes effect only at death, since it is not in force as long as the one who made it is alive." So, in terms of the presentation, I will run through what the outline of the presentation looks like. Essentially, I will be seeking to answer questions in this presentation. So I will seek to answer what a will is, what are the types of wills, who can make a will, and when you can make a will, why should you prepare a will, what are the features of a valid will, what information do you need to make a valid will, how may you alter your will, or how do you revoke your will, what is the legal effect of wills made as far as Ghana is concerned, how are wills preserved after your death to your will, and I'll conclude by just highlighting a few things you should remember. So I proceed. A will is a declaration of intention by a person of sound mind and of full age called a testator, consists of a property which he or she will be entitled to at the time of his or her death shall be disposed of, and how his or her affairs shall be managed after his or her death. Essentially, there are two types of wills, an oral will and a written will. In terms of the written will, there's a variation of a written will called a privilege will, which is essentially for members of the armed forces in active service. Who can make a will, and how can you make a will? If you recall the definition of a will, it's clear that the only two conditions that you need in order to make your will, you must be of full age, as in you should be at least 18 years of age, and you must be of sound mind. I wish to highlight the fact that you don't need to own property before you make a will, because if you recall the definition, a will does not only deal with the disposal of your property, but how you want your affairs managed when you die. So you don't need to own property before you make your will. So what is the purpose? What are the advantages of preparing a will? I will, for this purpose, highlight only two. One is to ensure that you solely determine how your affairs and property which you have worked so hard for to acquire are disposed of or managed. And two, to avoid family feuds after you are dead. I will tend to highlight what the features of a valid written will are. Obviously, it must be in writing. It must be signed at the bottom, at the end of the paper on which the testator writes the will. It must be signed in the testator, or a person appointed by the testator to sign the will must sign this in the presence of at least two witnesses who must both be present at the same time when the testator is signing the will. And as I indicated earlier, the testator should be 18 years of age before he or she can make a will. The testator must be of sound mind, and at the time he or she is making the will, must have in their mind that they are making a will and nothing else. And for a will to be valid, the property in it that the testator is disposing of should be self-acquired property, not property belonging to somebody else. So if you're a family head and you are taking care of family property, you cannot dispose of family property in your will. It has to do with only self-acquired property. And you must be, the person writing the will should be writing the will out of his or her free will and not be acting under any influence or undue or duress. I will now look at what the features of an oral will are. I must say that generally there are no conditions for an oral will to be valid. However, the person making the oral will must make this at the point where he or she is contemplating death. So on your dying bed, when you see that death is near, you may make certain declarations and they shall qualify to be an oral will. But beyond making these declarations, you must make them in the presence of credible witnesses who can testify that you indeed made those declarations in their presence and to their hearing. And again, these declarations must be made only with respect to self-acquired property. I now look at what information you need in order to make a will. If you decide to include in your will instructions about how your affairs should be managed after your death, including the kind of funeral you want and the kind of burial you want, you may want to include that as information in your will. You will need to appoint executors, at least two of them, who will then go through the necessary legal procedure to execute your will when you are dead. If you are setting up a trust, you need to appoint trustees to manage the trust. If you have people or beneficiaries in your will who are infants, you need to appoint guardians for that purpose. And you should properly describe the assets you intend to dispose of in your will. So if you have money in bank accounts, it will be important to state the account number, the branch of the bank, maybe even the currency in which the money in the account is, and how you intend to dispose of it. If it is land, you should describe the location of the land, the size, and if you have already registered it, it will be important to highlight what the registration of the land title registry is. You may also want to you may have acquired an insurance package, a life insurance package. You may have to aptly and appropriately describe it. You need witnesses to witness your will. Ideally, these witnesses should not be beneficiaries of the will, so that in the event that there's any contestation as to whether or not in your will, thoughts that these people influenced you because they are beneficiaries of the will. So you should get people ideally who are independent of beneficiaries of your will, and the two of them should be present at the time you are signing your will, the will. They should just be present and say that they saw you signing the will. And where, and this is just a general comment, where the person who is making the will, the testator, is illiterate or blind, there's a need for the content of the will to be read to the person in the language they understand, and they should be deemed to have understood it before it is valid. I now look at how you can alter your will. As you do know, wills are of no effect until you are dead. So you can change your will every day. You can change it once a year. You can alter it. You can amend it. You can revoke it at any time you want to do until you die. No alteration made in a will has any effect until it's separately executed in the same manner as is required for the execution of a will, or unless it has been made valid by the re-execution of another will or by a subsequent execution of a codicil. A codicil is just a mini will sort of, and it amends certain provisions of the will. But generally, if you look at anybody's will, one of the early paragraphs in the will says that you revoke all previous wills that you have made, just to show that the date of a particular will, if there are two wills made by the same person, the latter date of the will of the latter date is likely to prevail over the previous one. I will explain why I say likely. I now look at how to revoke your will. You may revoke your will by tearing it or any form of physical destruction. You may write a declaration of intent to revoke it and execute another will in the same manner as a will has to be executed. But you should note that a will which does not expressly say it has revoked a previous one will be deemed not to have been revoked to the extent that the provisions in that will are not contradicted by a later will. Since some of us may be abroad, I just want to say that a will made outside Ghana is recognized as valid if it conforms to the internal laws in force in the territory where the will was made. So if you're in the US and you make a will there, it is valid to the extent that it can be proved that you made it within the legal framework of the United States. Also, wills executed under the following circumstances shall be deemed to be valid. If you are on board a ship or an aircraft and you execute a will, it is deemed that they are valid based on the law in which the means of transport, the law of the country in which the is registered or is deemed to have close connection with. So if you're on board Lufthansa and you execute a will, it may be you are deemed to have done that within the laws of Germany if Lufthansa is registered in Germany. But in situations where the vessel may be registered in some place, like, I'm speaking to you right now from Liberia. Liberia is a place where, the people all around the world register vessels. But the vessels may be registered in Liberia, but may be working more in Panama. So the likelihood that if you execute a will aboard a vessel that is registered in Liberia, but mostly working in Panama, the laws enforced in Panama regarding wills will be likely to be the laws that will be used to determine whether or not your will is valid. I want to now look at custody of wills. A testator may, while he or she is alive, deposit for safe custody in the probate division of the High Court his or her will. Some may also decide to hand them over to individuals or keep them in other places, sometimes in the bank, other than the High Court. Where testator has duty, the moment it comes to your notice that the testator is dead, you have 14 days to deposit the will in the High Court, the probate division of the High Court. Other than that, you are guilty of a criminal offense. So if ever you are given the privilege to have custody of somebody's will, the moment the person dies, within 14 days that you get to know that the person is dead, you are under a legal obligation to deposit the will in the High Court registry. A failure to do that makes you liable of an offense and punishment. If you're interested in knowing what kind of punishment you'll be given, it's a fine or a term of imprisonment not exceeding 10 years or both. That should tell you that it's a huge offense, and you should be careful about taking up. If you have made a will and you are dead, then the will comes into force. But it's not automatic. The people you appoint as executors will have to go to the High Court and make an application for probate. The process will require that they will have to demonstrate that they are the witnesses. They will go through certain procedures. The court will have to satisfy itself that indeed these are the executors and this is the will made by so and so. And then after that is given, the will be read in open court. Sometimes family members will be there and hear who has been given, after which the executors will then go into the process of executing the will. They may have, where there are monies in various bank accounts, they may have to go around with the documents from the court, try and get all those monies, pay them into a central account, and then go ahead to distribute them as the testator has said it should be done. Where it is land, they will have to go through a process of vesting the land into the name of whoever the testator has said it should be handed over to. So a vesting assent will have to be prepared for that purpose. And I will by highlighting a few things. Where you do not make a will, you are deemed to have died intestate. And Act 111, the intestate succession law, will apply, and it provides for certain formula for distribution of property. And in this case, it extends across to the extended family as well. People may have life when you take a life insurance policy and you nominate somebody to receive the money upon your death, the person nominated to receive the money under the life insurance after your death will be the one to receive it, and it will not be the case that generally it will not be the case that will can supersede what is found in the insurance package. But if the person who you nominate predeceased you and you didn't change it, then policy will have no effect. I will also want to say that in a situation where you make a will and people who believe they are entitled to certain provision and that you didn't adequately cater for them, or you didn't cater for them at all, they may within 3 days after probate has been granted apply to the High Court, and the High Court, in going through satisfy and make sure that the people are catered for. And people who can make this application are your parents, your spouse, or your child who is under 18 years. And in the Constitution of Ghana even expressly says this, that if you haven't made reasonable provision for your spouse in your estate, then the spouse may go to court and your will be altered. So what is reasonable is a question of fact, but if you had 20 houses and you didn't give your wife one, or you didn't give your husband one, or you gave them one that is located in the village while she lives in Accra, she may successfully challenge your will and your will be altered. So just note that even though the will is aimed at making you rest in peace after you are dead, if you don't conform, or if it doesn't conform to the law, your will can be altered as far as the law is concerned. I will also want to state also that since the will is made, I mean, you make your will and you live longer, you may acquire property, and you may not have provided for that in the will. But every will has a clause called the residual clause. That clause is responsible for providing a general formula that says how your property, which you have not catered for in this will, but you will be entitled to at the time of your death, should be disposed of. So people may say, at the time of my death, any other property which I'm entitled to that I have not provided for in this will shall be distributed equally amongst my kids, or my biological children, or for so and so reason. And so that is an omnibus clause that is put in the will to make sure that as much as possible you are able to determine how you want your affairs to be done. Now, with this overview, I want to think that if you adhere strictly to what your will be done on earth as you rest in peace. Thank you very much. I now welcome questions.
All right, thank you, lawyer. I think whatever you are, you agree with me that he deserves an applause. So yes, do it, and I'm sure you will feel it. So the questions appear on the right, on the right side. So Mr. Agyakwa, I don't know do you want me to read out the questions? I'm reading out the questions and you answer them because the questions appear on the right hand side of our screens.
Yes, I mean I just stopped sharing the screen. I just stopped sharing the screen, so the questions are yet to pop up. But maybe you should start reading them so that we can save time.
So that we can see how we good. All right. The first you have touched on some of them anyway. Well, the first question has to do with alteration.
The questions are not no, they are not appearing.
They are not appearing. Then I'll do you the honest part.
So Edwin, I'll suggest let's read out the questions and then he can respond for now.
That is okay. That is okay. So I'll be reading a few. Richard will also be reading a few, so that at least we don't hear only one voice. So, lawyer, I think the first question has to do with alteration. What processes does an illiterate need to go through to appoint someone to sign on his behalf? And is there any chance of being able to use fingerprint? This is from Kojo. An illiterate trying to prepare.
It is possible for an illiterate to tamprint. The law also makes it possible for somebody to sign on behalf of the illiterate, on behalf of the testator. I mean, if for instance you have a stroke and you cannot sign, you may ask somebody to sign on your behalf. For an illiterate, it will be important to include in the will what in law is referred to as a jurat. A jurat is a declaration made by somebody who is literate, saying that he or she read the contents of the will to the illiterate person,
right,
and explained it to the illiterate person in a language the illiterate understands. And the illiterate did appear to understand the implications of what was in the will. And that person will then sign that jurat in addition. So in the event that it is found out that that declaration is false, it will be, or it could be, the subject of criminal prosecution.
I think that's well answered. Yes, with your kind permission, I'll move on to the second question. Rich, could you do us the favor by highlighting the question we want to ask?
Okay.
The second question.
All right. So another question from Ernest Atukwe is that what is the cost implication for depositing a will at the High Court? And are the High Court judges involved? In which case, can material substances such as goat or yam cash equivalent be used in place of cash? I think the substantive question really is what are the cost implications? Yes.
The cost is negligible. I don't recall what it is, but it's very negligible. And when you deposit the will, it is sealed with a substance that seals the envelope. And the moment you go back and that is tampered with, it's evidence that in fact, you can only break the seal by destroying the envelope. And you usually will deposit 3 copies. You will prepare 3 copies of your will and have them sealed in the way that I'm talking about. And then one is deposited at a High Court, the probate division's registry. And then you can keep one. Usually the lawyer will also keep one. Now, it isn't the case that I know not of any case where judges keep custody of the will. And so I don't think that you should be worried about it being exchanged for the goat.
All right, that is well rendered. Now, we go to the next question from Seth Wachiosu. Seth wants to know, can an executor be a beneficiary under the same will that he is appointed to? He is appointed as an executor. Yes, can one execute a will in which he is also a beneficiary?
Yes.
Oh, simply yes.
Hello.
No string. So it's
just
yes.
The answer is yes.
Yeah. All right. Yeah. So Rich, please.
Okay. So a question from Kwame Andokumi. How often do I need to amend my will? Is there a stipulated duration for amendment?
There's no stipulated, time for amendment. As I did say, the will becomes effective only when you are dead. So, practically you can change your will every day.
All right. Okay, thank you. I think that is fairly straightforward. The next question also from Seth Usu, and I read, what's the minimum requirements for witnesses in terms of number of people who can witness the will? Number of witnesses.
Minimum. Two of them.
Minimum. Is that a minimum?
Two of them. The law requires that there should be two witnesses.
Okay. All right. That is fairly straightforward. Rich.
Okay. We have this question that's the last question from Seth Boachi Owusu. Please, if there are any more questions, you can send them in like now. But the last question we have on the list now is that what constitutes an active service in the Army?
The law doesn't define what active service means. Active service will be a question of fact. The fact that you're a member of the armed forces and you are, for instance, maybe undertaking duties in Bimbila, there's a curfew, you may be in active service. If you are lying in your room in Bema camp, you may not be in active service. I want to even believe that given the kind of jobs that our police are currently doing, it may be possible that this provision will cover police, but that is not what the express provisions of the law is. So for now, it's armed forces.
All right. I think that, as far as posts are concerned, that's the last question. But I have a question myself. I think Rich also has a question himself.
Yes. And Edwin, I think at this stage it's okay to turn on your camera
all right.
also. So let's just.
Okay. All right. So, thank you, lawyer. I have a question myself. I wanted to know, how do we determine the validity or the authenticity of a will when when I die? How can how can one tell that it is an authentic will and not one forged by my wife? Authenticity of wills. How can we ascertain the authenticity of a will when the person who made it is dead?
So there are a number of things. One, I have indicated what the essentials of a valid written will are. I've also said that it has to be deposited in the High Court registry. Now, in the event that there is a feud about the truth or otherwise of a will, it will be the court that will have to determine, based on the evidence that either party will lead, to show that this will is indeed prepared by Edwin or it was forged by his wife.
All right, that is a pretty good safeguard enough. Well, Rich, any question from you?
Yes. So Samuel, in the case of joint property held between a couple, what are the technicalities to consider in structuring your will such that you have cognizance of that sort of arrangement?
Okay, so the Constitution of Ghana requires that Parliament passes legislation to regulate properties of spouses or people who are in a marriage relationship. Now, this Constitution came into force in 1993, but Parliament is yet to pass that legislation. There's currently a bill before the legislature before Parliament to deal with this particular issue. But I would say that wills you cannot have a joint will. So wills are individual matters. Now, depending on how you want to look at it, as I indicated, if a spouse is of the view that the dead spouse did not make reasonable provision in his or her will, the aggrieved spouse can go to court. So, for instance, if you do have one matrimonial home or one house in which you live that is deemed to be your matrimonial home, now there is no point if you did your will and said, oh, you were the breadwinner and you built it, and so you decide to dispose of it in another way other than leaving it for your wife and your kids. It will be reversed by the court. If you did have more than one house, which you acquired during the marriage, both of you have equal access to it, you may decide a number of things. Either you decide in your lifetime to transfer your interest to your other spouse, so that then they become owners of it and can deal with it in a manner that they require. Or in your will, you do say that your interest in the house you do give to your spouse. In the event that you predecease your wife, your spouse may then be the sole owner and can then decide to pass it on to your kids or whoever. In the event where she predeceases you, it then becomes yours, and you will then decide how to dispose of it.
Okay. All right. I think we have some 2 or so more questions from the audience. So I'll read out the first one, Edwin, and then you take the second one. So there's a question from Joseph Mensah. And he's asking, what if he has more than 2 witnesses? Are you allowed to basically have more than 2 witnesses to your will?
Yes, you can have 2 or more.
Okay.
But if you're going to if it's probate, if you are going for probate, the standard form requires 2 people. So you can have more than 2. It's not against the law. The idea of having more than one is so that one person can support what the other person is saying, and should one of them be dead, you at least have one person. I mean, there was one case, for instance, I did, where the witnesses to the will, the testator used to work for GNTC or one of those defunct organizations, and he called witnesses from the sellers who were selling around Ghana House as it was, and he was dead. We were taking probate. We couldn't find these people, but fortunately there was provision under the law that made it possible to proceed to take probate without the witnesses.
All right, that is well answered. Well, we have a question. You touched on this question, but you remember the question where there appeared to be a caveat in the title. And that's what the question the questioner Nathaniel Amte want to re-ask. You stated, I'm quoting him. That's a question from Nat.
Mm-hmm.
You stated that if one wills a property in the village to a spouse, the spouse can challenge that. In such cases, I think your will no more becomes, in quote, my will be done. You explain that. I don't know whether if you can explain again.
But yes, so one, let's not go into speculation, and let me not be misquoted. I gave a scenario that if you lived in Accra and you had 6 houses or many houses, some in Accra, some in the village, and you decided that you were giving to your wife a house, and you gave her a house that was in the village and not one that was in Accra. For a woman who has lived in Accra and does everything in Accra, the laws require that you do make reasonable provision for the person. So if you refused to do that, you went against the law. And if the person goes to court and the court rules in her favor, Yes, your will will not be done, but it will not be done because you didn't respect the law.
All right. In fact, that is a crux of the issue. Where one deliberately or not, wittingly or not, one does not respect the will. His will, he cannot have his own way when he's dead, and that is
you respect the law of making wills, and then you rest in peace, and your will will be done.
All right. That is right. All right. So no in law. All right. Okay,
yes. So I take maybe 3 more, and then there's one that someone has sent to me on the blind side that is coming from our sisters on the mountain. But so first we take the ones from the gents. So Eric Chinny asked, what happens if I die in the process of amending my will? Will all nearly amended by my signature? I don't get it too well, but I suppose the question really is that if you are in the process of amending a will and you pass on, what happens?
I mean, it should be a question of fact. If you made a will, a written will which you deposited, and then on your dying bed you decide to revoke or alter it orally, I think that it will be a case of looking at the entire facts and deciding whether or not this was seeking to amend the will, and then you to go. I mean, you will have to pass the test of a valid oral will, which will be that you made it in the contemplation of death. It had to do with self-acquired property, and you made it before credible witnesses who are willing to testify that they were there and when you said this.
All right. That is good. That is good. That is good. All right, lawyer, thank you. I think this also touches on what you answered, the question you answered, before Rich came in. Does a will have to be fair? Philemon wants to know. Does a will have to be fair? Maybe let me add a second one. Can a will that respects the law of making wills, can it respect the law and at the same time not be fair?
What is fair is a question of fact.
All right.
That is why the law does not say that it should be fair, but says reasonable provision.
Right.
So the fact that you have 10 houses, that doesn't mean you should give 5 out to your spouse. It may mean you should give 5 out to your spouse, but it could also mean you should give 1. If you have 10 houses and one is in airport residential area and the rest of them are in a village, and you gave the one in airport residential to your wife and gave the 9 others to other people, it will not be fair, but it's reasonable. The court will be looking at the totality. I mean, a dispute will arise only when there's an aggrieved party. If there's no aggrieved party, there will be no dispute.
Right. Right. All right.
Or in fact, there could be an aggrieved party who will go to court.
Oh,
okay. So I take the last one from the brothers, and then we'll chip one in from the sisters. So Natalamte asks this question: what are the breakdowns in the interstate law in terms of sharing property? So what are the guides that the law provides interstate?
I mean, it's a very cumbersome, long, winding, what do they call it, formula. But if you want to hear it, 3/16 of the property will go to the surviving spouse. 9/16 will go to the surviving child or children. 1/18 will go to the surviving parent. 1/18 will be disbursed according to the person's customary law. You understand? So if you look at all this fractions, and I mean, if you can avoid it, avoid it.
So let me bring on the one from our sister from the mountain. So the question
But
is,
before you ask the question,
yeah.
Before you ask the question,
Yes.
you should have said to me that there were ladies on board. Maybe I would have even done things differently.
Okay. Yeah, we put the first one on you. We didn't want you to do it any differently. So sorry about that. Now the question is, what if an older will is executed before a new one is found? Okay, what if an older will is executed before a new one is found?
I can see the lawyer contemplating and trying to put some. That is a good question.
I don't understand the question. I don't understand the question. Are you saying that what happens if there are two wills and there's an old one and a new one?
Yes.
I kind of think so. Yes, that there's one that probably has a newer one, and maybe in the things of the deceased, you find a copy of the older one and you try to execute it.
Okay, so this again also depends on the facts. As I did say, you could always change your will, and you can revoke your will. You can alter your will. Now, if the old will is dated, let's say 1965, and there's a new one 1970, to the extent that the new one says, I revoke all previous wills made by me, it means that the previous will is dead. If it didn't say so, if the new one doesn't say so, but then you find provisions in the new one that contradicts the old one, the new one will prevail. But the most important thing is that there should be evidence that the new one supersedes the first one, and that the first one has no life. Other than that, the circumstances will require that, to the extent that both of them are legal, both of them will be read together to resolve what actually the will of the person was.
Lawyer, I think we have some intricacies in there. So, assuming the disbursement has been done based on the older one, do they recall everything and then re-disburse based on the newer one?
You see,
Yeah.
when you have written your will, one, as much as possible, you shouldn't make it a secret document. By not making it a secret document, it doesn't mean that you should share the contents. But if you have a will, you have deposited it. When you die, the first thing is to go to the probate registry to see whether the person has got a will there. And I will tell you, not too long ago, I even had to find a will that was made in the 70s. When you go to the probate division, you will get it there. So the person who has made a will and has deposited it, the first point of call, as I say, should be the probate registry. If you went there and you didn't find it, but you did know the person has made a will, the next place you may have to go is the person's lawyer or the person's close friends. That is why, if you recall, I also said that if you are an individual who has custody of somebody's will, within 14, the person is dead, you should deposit the will at the registry. Other than that, you'll be found guilty of a criminal offense and you will be fined and or imprisoned for 10 years. Right. So where, under some mistake, they went for the old one and they have discovered a new one, the first determination is whether or not, in fact, the new one is the person's will. Right. And if it is, you may have to take steps to reverse it. That will create a lot of anarchy. And as the one writing the will, if you intend to rest in peace, you should make sure that you don't make this happen.
It is true. It is true. It is true. Thank you very much. There's a last question, but I think you've covered it. There's not like joint will. I think you covered that. A wife and husband cannot. Yes.
Yes. Yes. It was covered. It was covered.
It was covered. It was covered. It was covered. Yes. Rich, can we end on this note so that
A wife and husband cannot do joint will.
All right.
But they can agree in separate wills and say that this is our house we are giving to our children.
All right.
So if both of them die together, it goes to their children. If one died before the other one can decide that they will perfect it and let the child have it.
All right. All right.
You can also say that the interest you have in the house you are giving to your child.
Right. Right. Rich, on this note, I think I'm good to really, present the closing remarks.
Yeah. Okay.
Right.
Quickly, maybe for me, just on a technical note. I just want the viewers the audience to understand that, of course, this is the very first one in the series, and we run into some hitches that we never thought would be the case. However, just so that we all appreciate what has been achieved today, Lawyer Agyakwa is actually sitting in Liberia, okay, and he's presenting this all the way from Liberia. Today we've had guys who have joined from the United States. Some guys have joined from Canada, the UK. I don't know where else. Later we'll look at the analytics and see where various guys joined. I had to drive on to my office from home because I lost power, unplanned. And I know Edwin has also had to move into his office. It's already 11 p.m. in Ghana, and so I mean, this is what it's taking to pull this off. It's the first one, and the hope is that we'll get better at doing this. So, Edwin, please give the closing remarks. Then.
Thank you, Rich. Yes.
Edwin, before you do that,
right.
Edwin, before you do that, I think there's this question I've just seen on the platform that says, can one include how and where he should be buried in a will? And the answer is yes. The will also provides, we can give burial instructions in the will.
All right. Thank you. Thank you. And that makes you take control even whilst you are dead. Thank you so much. On this note, I want to thank Lawyer Opoku so much for availing himself to present to us this important thing. I tell you, I have gained so much, and I think I am, ready to put my will together. And I know so you are, at least, to decide to do something so that you take control of your life or take control of matters whilst you are dead. Lawyer, we thank you so much. We thank you so much. This is the first in the series, of course, the media edition. And believe you me, Lawyer Agyakwa has shared his knowledge with us. Look, he has not lost a bit of knowledge. In any case, he has sharpened what he has. But all of us have gained. When we share knowledge, we gain. It is win-win, and so we encourage all of us to be available, during subsequent presentations. Lawyer, we thank you so much for availing yourself. We also want to thank Rich for the technical support. You know what? Hey, I'll rest it. It's always there, and so executives would want to see whether we can use this platform to hold our meetings, quarterly meetings, half-year meetings, annual meetings. Yes, if we come it physically, we can hang out on Google. On this note, friends, the last time go to you. If you were not there, if you didn't join in, everything would have been fiasco. So we thank you so much for being available and for being present. Rich, you can give us the number that attended. I know we can get a number, later. Yes.
Yeah, I'll share the statistics later. Yeah.
Later, right. So, friends, we thank you so much for joining in and making the media edition so wonderful. To our girlfriends, yes, we thank you so much for also, representing. Lawyer, once again, we are grateful to you for your time. Thank you so much.
Bye-bye.
Thank you very much. I enjoyed the interaction. It was a great privilege. I'm happy to have been of service, and I hope that I shared something.
Illuminate.
It is the case that culturally death is not something that we talk about or we contemplate.
Yeah.
But unfortunately, the truth is that it will come.
Yeah.
So let us take control of our affairs and try and rest in peace whilst our will is done on earth. Thank you very much.
Thank you very much. Rich, we're going to have some YouTube video.
Yeah. So
right.
guys, we'll send a link to the recording, the YouTube recording of this, and so you can play it back anytime. Take your time and get the understanding. And of course, we'll get the presentation as well from Lawyer Agyakwa and share it in Telegram and other sort of platforms. Yes.
All right. On that note, I want to say thank you as Rich disperses us.
All right. Bye.
All right. Bye-bye.